So welcome everyone to the first Truth and Reconciliation event hosted by Strigberger Brown Armstrong. My name is Carolyn Meyer. I'm a partner at Strigberger Brown Armstrong, and we are an insurance defense litigation boutique with offices in Toronto, Kitchener-Waterloo, and London. As we are all aware, today is the first Truth and Reconciliation Day passed by our government. The day honors the lost children and survivors of residential schools, their families and communities. Public commemoration of the tragic and painful history and ongoing impact of residential schools is considered to be a vital component of the reconciliation process. And we are privileged today to have joining us Mr. Stephen O'Neill. Mr. O'Neill's legal career spans more than 40 years. He was appointed a judge of the Ontario Superior Court of Justice in 1999 and retired in 2015. Before his appointment as a judge, Mr. O'Neill practiced law out of Sudbury and focused on Indigenous legal and justice issues. He has traveled extensively throughout Northeastern Ontario and has written and spoken extensively on Aboriginal and Crown Aboriginal issues. He recommenced the practice of law after retiring from the bench in 2016 and has devoted his practice solely to First Nations issues. In 2009, Justice O'Neill determined to paddle across Canada, following the historic route of the Voyageurs. He has reached Yellowknife and will undertake the final phase of his voyage in 2022. Mr. O'Neill's experiences are a model for us all as to the role that law can play in reconciliation. Most of us on this event are involved in the justice sphere, and insofar as insurance touches upon those issues. And so we are privileged and grateful for Mr. O'Neill's time today to speak to us. Just a couple of housekeeping issues here. We do have a strict 1 hour time frame for Mr. O'Neill. And you'll notice that you should have gotten a notification that this event is being recorded, and it will be posted on our website at its conclusion. In respect of us being able to have a dialogue with Mr. O'Neill, you'll note that there is a chat button function at the bottom of the screen, and that will allow you to put forward your questions throughout Mr. O'Neill's speech, and at its conclusion, we'll hopefully have time to address as many of those questions as we possibly can. And so in that respect, I will let Mr. O'Neill take it over. Sir, on to you.
All right. Well, thank you very much, Carolyn. I'd like to extend my greetings to all of you. I'm located on what is known as Robinson Huron Treaty Lands here in Northern Ontario. And I'd like to thank you very much, Carolyn, and the members of your firm for hosting this. It's a wonderful act and a wonderful thought. And it shows us that these questions around truth and reconciliation permeate through Canadian discourse, the judicial system, the legal system, and they touch all of us. I have a little CD for you guys. That's my friend Hardy Pelche from the Wikwemikong Unceded Indian Reserve on Manitoulin Island. I worked with Hardy from 1984 until 2016. Hardy passed away in October 2016, and I spoke at his passing. But Mr. Pelche taught me as much or more about the law and justice as I could ever learn in a Canadian law school, or I could ever learn in my practice of law I would say that Hardy and I spoke on the phone 5 to 7 times a week and visited each other 4 to 6 times a month in that period between 84 and 2016. I'll have more to say about that in a moment. Because we're on a national day holiday of truth and reconciliation, Hardy was sent to the Spanish residential school. Spanish is a little community located between Sudbury and Sault Ste. Marie. A lot of people from Manitoulin Island went there, but my buddy Hardy jumped out of the second floor window 2 weeks in. They chased him back to what we call Wikwemikong, but he hid out pretty good, and he didn't go back to the school. I'm going to refer to 5 articles today that Carolyn has. 3 of them I've written, and 1 is a piece of legislation, and the 5th one is a court decision. And Carolyn, you can make arrangements to circulate those to your listeners at the request. My email is soneill, all one word, that's SONEILL at NNC firm, that sounds like Nancy Charlie firm, NNC firm, all one word, .ca, if you have any questions. We're going to start with an article called Binjabayong, which I wrote on one phase of my cross Canada paddles. And Carolyn, you can get this too. I'm just going to read from the article. The eyes of our canoe's Thunderbird logo had seen close to 25 Aboriginal communities on its paddling trip between Montreal and Lake Winnipeg. Carolyn is correct. I've reached Yellowknife on Great Slave Lake, and next year my partner and I want to head from there into the Mackenzie, down the Mackenzie to Toyaktuk. So when I wrote this article, I had only reached Winnipeg. The great majority of these communities were in northeastern and northwestern Ontario, and many people along the way asked the question, why do Aboriginal people live in these places where the pine trees or the spruce trees on the hills meet the waters on the shores of the lakes and rivers? And I answered in my article, they live here because these communities are their homes. They live here for their deep and strong connection to the traditional lands and waters. They live here for the seasonal changes. They live here, and even if they move away or are unable to move away, these places and communities, Oka, Nipissing, Wikwemikong, Saigamuk, Garden River, Mishippocaton, Wabaseemoong, Saugeen, Hollowater, and all places and communities in between will always be home. And then I went on in my article to say, but in the end, the question, why do these people live here? Why don't they just move? Seemed far less important than did the path towards understanding, respect, and reconciliation. In volume 1 of the final report of the Truth and Reconciliation Commission of Canada, the commissioners put it this way. Carolyn, are you able to hear me okay as I read? You can hear me okay? You can hear me all right?
Yes, we're just muted. I stay muted while you speak.
We believe that reconciliation is about respect, wrote the commissioners. That includes both self-respect for Aboriginal people and mutual respect among all Canadians. All young people need to know who they are and from where they come. Aboriginal youth and children searching for their own identities and places of belonging need to know and take pride in their Indigenous roots. They need to know the answers to some very basic questions. Who are my people? What is our history? How are we unique? Where do I belong? Where is my homeland? What is my language and how does it connect me to my nation's spiritual beliefs, cultural practices, and ways of being in the world? Youth also need to know why things are the way they are today. That requires an understanding of the history of colonization, including the residential school system and how it affected their families, communities, their people, and themselves. And the commissioners went on in the report to write as follows: of equal importance, non-Aboriginal children and youth need to comprehend how their own identities and family histories have been shaped by a version of Canadian history that has marginalized Aboriginal people's history and experience. They need to know how notions of European superiority and Aboriginal inferiority have tainted mainstream society's ideas about and attitudes towards Aboriginal peoples in ways that have been profoundly disrespectful and damaging. They too need to understand Canada's history as a settler society and how assimilation policies have affected Aboriginal peoples. This knowledge and understanding will lay the groundwork for establishing mutual respectful relationships. Now, I'm going to end the first article there. We will move on to the second one, but just before I leave it, I would say to all of us, if I've learned one thing in all my paddling and my work and my connection to the communities, this is, my friends, about respect, no more or no less. It's about respect. If you could take it down to one word, people like to say reconciliation. That's a good word. Truth is a good word because there can't be restoration, reparation, reconciliation without truth. But the act that all of us can extend to each other is this act of complete respect. All right, we'll turn to the next article. Next case, I'm holding up a 132-page decision. You can see me okay, Carolyn? I can see you. This is a case called Restoule. It was decided by Justice Hennessy in December of 2018, and it has to do with the Robinson-Huron Treaty involving 21 First Nation communities in Northern Ontario. And just to get a sense of the size of the territory, the treaty would run basically from Batchewana Bay on Lake Superior. It would follow the coastline to the Sioux. It would run Georgian Bay right down to Penetanguishene. And then inland, this treaty would push over the top towards Temagami and north of North Bay in the Nipissing area. It would then track south, let's call it somewhat west of Highway 11, traveling south from North Bay. And then as you get down by sort of Sundridge area on Highway 11, the treaty territory tracks inland towards through Port Carling and Rosso and attaches back to Penetanguishene. So consider that within this treaty, you have Sault Ste. Marie's community, you have Sudbury, you have North Bay, all the communities in between. And of course, you have the Parry Sound to the south and all of the Indigenous communities affected by this, including 4 communities on Manitoulin Island whose beneficiaries or members are part of this treaty. This case is under appeal. The Court of Appeal heard this decision in April and June. We're awaiting their appeal. And so I'll choose my words carefully and respectfully. But I'd like us to turn to page 77, if we could, of that decision. And you'll rather page 74. I know we're speaking with people trained and learned in the insurance world, insurance contracts, wording, legal wording. What is a contract? What does contra preferentum mean? Who is a contract to be interpreted in favor or against? So some of this will be familiar to our listeners, but I thought that I would read what is now settled in Canadian law. What are Canadian treaties? What are these treaties that were entered into between First Nation peoples and the Crown? And how do you make sense of a treaty? How do you understand it? How does the law? So at page 74, Justice Hennessy said, the task before this court requires the consideration and application of the well-settled principles of treaty interpretation to determine the treaty's promise. As the Supreme Court of Canada states, the purpose of historic treaties such as the Robinson treaties is to reconcile the pre-existence of Indigenous societies with the assertion of Crown sovereignty. Therefore, treaties must be interpreted in a way that achieves the purpose of the treaty, gives effect to the interpretation of the parties' common intention that best reconciles the interests of the parties at the time the treaty was made, and that promotes the treaty's reconciliatory function. The principles of treaty interpretation were first summarized in the Marshall decision, and some of you know about Marshall. This is Donald Marshall fishing for eels in the late 1990s, the same Donald Marshall who was wrongfully convicted of murder many years before that. And in the Marshall Treaty case, the Supreme Court of Canada says Aboriginal treaties constitute a unique type of agreement and attract special principles of interpretation. Treaties should be liberally construed, and ambiguities or doubtful expressions should be resolved in favor of Aboriginal signatories. In searching for the common intention of the parties, the integrity and honor of the Crown is presumed. In determining the signatories' respective understanding and intentions at the time of treaty signing, the court must be sensitive to the unique cultural and linguistic differences between the parties. Treaty rights of Aboriginal people must not be interpreted in a static or rigid way. They are not frozen at the date of signature. The interpreting court must update treaty rights to provide for their modern exercise. This involves determining what modern practices are reasonably incidental to the core treaty right in its modern context. I'll ask Caroline to turn to page 92. Before you look at page 92, listeners, consider this. Section 35, if you're going to write a few things down today, write down Section 35 of the Constitution Act 1982, which states that the existing treaty and Aboriginal rights of the Aboriginal peoples of Canada are hereby affirmed and guaranteed. I'm just going to pause for a moment on this point. When we brought back our Constitution from England in April of 1982, there's a famous picture of Pierre Elliott Trudeau and the Queen in April of 1982 signing the Constitution outside the doors of Parliament. And that's where our Constitution came home to Canada. But before that happened, a delegation of First Nations people went to England, and they went before Lord Denning, and lawyers listening to this will know who Lord Denning is. And they said, you can't take the treaty promise section out of the BNA Act of 1867. That's got to stay with England because the treaties were signed with England. These treaties that were entered into between the Crown, beginning with the Treaty of Niagara, 1764, all the way up to treaties signed in 1982, were seen to be treaties entered into with the English or the British Crown. And the First Nation people say, if you move this to the Constitution to Canada, this section, we're stranded. And in that court case of 1981, a year before the signing, Lord Denning said, as long as the rivers flow and the grass grows, treaty rights will continue. So this idea of Section 35 in the Canadian Constitution is almost the core element of what's going on out there today. That is to say, the existing Aboriginal treaty rights of the Aboriginal peoples of Canada, the Métis, the Inuit, and First Nation peoples are hereby affirmed and guaranteed. And I want to go on and say something else. Maybe make a note of a case called 2004 Haida, H-A-I-D-A, Haida Nation, where the Chief Justice of Canada, Beverly McLaughlin, said, Canada's Aboriginal peoples were here when the Europeans arrived and they were not conquered. One of the misconceptions on the streets and in the Tim Hortons of every community I walk on, and listen, I've been to a lot of places, is the idea that the First Nations were conquered. But you see, after 1763, the Treaty of Paris, 1760, there were uprisings known as the Pontiac uprisings. And there were seizings after the battle on the Plains of Abraham. Forts at Fort Detroit, Fort Pitt, Michilimackinac, and other places were seized by Odawa, O-D-A-W-A warriors. Interesting, I should say Odawa, because this man, Mr. Pelche, is from the Odawa community of Wikwemikong, Manitoulin Island. So Chief Pontiac began the Pontiac uprising. And King George quickly realized that British North America could not be held without a relationship with Indigenous people. So the Royal Proclamation of 1763 was passed. It said that the Indigenous lands of this country could not be bought by anybody other than the Crown, and the Crown cannot buy these lands unless it entered into a treaty with First Nations people. And only after the Crown entered into a treaty could it sell the lands. So anybody listening who lives in a condo, a house, has a cottage property, if you look at your deed and go back and you have somebody do a real estate search, you'll see there's a first Crown patent. It'll, on the registry system, will say that the first sale of this land happened in 1933 or it happened in 1896. But before that sale could happen, and before you could buy your place in Toronto, Waterloo, Kitchener, Northern Ontario, there had to be a treaty with the Crown. They don't show the treaties on the land titles registrar. They just have Crown titles starting then. So I wanted to point that out. And now we'll go to page 90. I think we said 92, Carolyn. And I wanted to read a little more about the meaning of treaties. A proper analysis of the treaties must take into account the following historical and cultural context. Anishinaabe, this is the Anishinaabe people of Northern Ontario in this Robinson case. The Anishinaabe perspective, particularly looking at the concepts of respect, responsibility, reciprocity, and renewal, as manifested in Anishinaabe stories, governance structures, and political relationships, including alliance relationships, is important. And the judge went on to say, we have to look at the Crown's perspective entering into treaties as seen through the eyes of the colonial government. We have to look at the historical record of claims and grievances by Anishinaabe chiefs and leaders. We need to look at the Treaty Council. In the case I'm dealing with is the Treaty Council of September 1850 that led to the Robinson-Huron and Robinson-Superior treaties. We need to look at the Treaty Council, the minutes created by Commissioner Robinson at the time of the treaties. We need to look at his diary, his official report. We have to look at issues concerning interpretation, transcription, and drafting of the treaties. We have to look at the post-treaty record after the signing of the treaty, and we have to look at the honor of the Crown. So I wanted to point that all out to you. The Rastool case will be sent to you, and it really is it talks about the foundational treaty of this country, the Treaty of Niagara, 1764. I really urge folks who are interested a little bit in Northern Ontario and what this is really about is this is a great educational read. Bear in mind, it's about the annuities, the $4 per year per person, and that it is under appeal by the Court of Appeal. But many of the facts in the case are accepted and not in dispute. All right, Carolyn, let's move to my Manado Balwittigan article, which you and I called Part C. This is an article, folks, I wrote called Through Manado Balwattigan and the Lake of the Everything, a feather's journey to a court of justice. And you might say, well, look, Mr. O'Neill, what kind of canoe are you paddling? Like, what kind of ship are you on? I mean, you know, I've been around, Mr. O'Neill, 30, 40, 50 years. I've never heard of the Lake of the Everything. Where the heck is the Lake of the Everything? Well, there isn't a Lake of the Everything, but there is Lake of the Woods. And I kind of changed the story to talk about a paddling trip from Fort Frances down the Rainy River across Lake of the Woods to Kenora, because Lake of the Woods is sort of Lake of the Everything. And I'm going to read to you from this article that I wrote following that trip. And I pick it up as follows. As we paddled through strong northwest winds, I thought about barriers to reconciliation caused by distrust and misunderstanding. I recall that in the summer of 2000, then Globe and Mail columnist John Stackhouse had hitchhiked from the East Coast to the West Coast across Canada. He had written a series of articles about his trip, describing the people he met and the places he visited along the way. On September 13th, 2000, when he was halfway across the country, he wrote, I was just beginning to discover how much resentment and distrust they, the natives, also face. As the nightly news showed more scenes from Burnt Church, New Brunswick, I found that among non-natives there was a disgust that cannot be underestimated. My first taste of Canada's hidden anger had come in St. John the day I started the trip. Having reached the West Coast, he wrote in his summary or focus article as follows, and everywhere I heard anger about Native Canadians. You know, it wasn't easy for me to write this, but it's been written. I reflected that what John Stackhouse had heard and observed a mere 14 years ago mirrored to some extent what I had heard and experienced paddling westward between Montreal and Kenora during each of the past 6 summers. Along the rivers, lakes, and waterways, and through numerous communities, I listened as Canadians from all walks of life, lawyers and judiciary included. And my friends, you'll learn an awful lot on a break at a judicial or legal conference when you talk to your colleagues with muffin and coffee. That's when a lot of stuff comes out. And you guys, if you haven't learned that before, this is a teaching moment for you. I've learned a whole lot with a muffin in one hand, a cup of coffee in the other, and what people really think about this, that, and the other thing. And so I went on to say, as people explain their views in relation to Aboriginal people and Aboriginal legal issues, Justice Binney best described the reconciliation of Aboriginal peoples and non-Aboriginal peoples when in the Mikisew Cree case in 2005, he wrote, "The fundamental objective of the modern law of Aboriginal treaty rights is the reconciliation of Aboriginal peoples and non-Aboriginal peoples and their respective claims, interests, and ambitions. The management of these relationships takes place in the shadow of a long history of grievances and misunderstanding." I paddled through the Mikisew Cree community a few years ago, and that's up north of the tar sands of Alberta. That was quite a paddle heading up the Athabasca River, finding a place to camp at night. You couldn't drink the water in the river. And then the Athabasca flows into Lake Athabasca, and then out of Lake Athabasca flows the Great Slave River. But I was happy to be able to paddle through Mikisew Cree territory. How many more minutes do I have, Carolyn? Are we doing okay?
Yes, we're doing fine. We've still got half an hour.
Okay. So turning the next page of that article, I went on to write, for some people, the constitutional legal rights of Canada's Aboriginal peoples, rights that are to be construed in a liberal and purposes manner, could best be categorized or described by the following questions or assertions under a heading that might read reconciliation. I thought that was pretty, those are my words, not reconciliation, but reconciliation. This is all in the past. Why should we have to pay for it now? Well, remember, the existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby affirmed and guaranteed. That's the highest law of Canada. So that's a constitutional promise. Treaty rights are so vague as to be meaningless. Why should Aboriginal peoples have such rights anyway? Wasn't this all settled in the Indian Wars and a result of the 7 Years' War? Why should there be 2 sets of laws, one for us and one for them? What's so special about the Royal Proclamation of 1763 and the Treaty of Niagara 1764? Why honor the treaties anyway? Why can't they just learn to adapt and assimilate as all newcomers to Canada must do? And then I went on to write, there can be no doubt what reconciliation camp the Chief Justice of Canada belongs to. In the Chilcotin decision, British Columbia, 2014, a unanimous Supreme Court of Canada granted a declaration of Aboriginal title over a defined area, marking the first such declaration in the court's history. In penning her decision, Chief Justice McLaughlin repeated the phrase reconciliation 13 times. And you can turn over the page, Carolyn, to the last page. And then I go on to write, as our canoe drew further and further towards the lake's north end, and this is the north end of Lake of the Woods, I reflected, if the legal mandate is reconciliation as it is, and if we are to move past misunderstandings and distrust, we must then come to know one another. And so to that list of earlier questions and statements set out above, I thought perhaps there could be added the following under the heading reconciliation. Have we visited First Nation communities other than for court purposes? Can we count as among our friends some Aboriginal peoples? Have we tried to understand their laws, their beliefs, and their deep connection to their traditional lands and waters? Have we educated ourselves about their treaty history and the solemnity of their relationship with the Crown? Do we respect them? Do we trust them? Can we do more? Ruth Ann Onley, in a Globe and Mail article dated September 22nd, 2014, entitled How We Build a New Relationship with Ontario's First Nations, described the work of reconciliation as follows, quote, A word that came up many times before, during, and after our stay in KI was reconciliation. In the context of our visit, rather than a transaction or a process, reconciliation meant dissolving a relationship that no longer works and building a new one by watching, listening, and learning. And so that's what I wrote in this article. When you're paddling along on some of these trips, you have lots of time to think. You think about your family, you think about your kids, you think as later as I paddle in life, your grandkids, you think about your spouse, you think about your health, you think about, I even had to think about my law practice a little bit. Like the lawyers say, where is this guy? I just say, well, I'm out getting educated. Just, I'll be back at the office. Don't wait for me, but I'll be back there. But you do a lot of thinking. And most of these articles, I sort of had them written in my mind by the time I finished paddling. All right. So I just wanted to say more things before I move on. Where I just wrote to you, I mentioned KI. I talked about Ruth Ann Onley, who was visiting in KI. Well, that's the community near Big Trout Lake, northwest of Thunder Bay. I was involved in that case. That's the Platnex gold mining case where the KI people said, look, we can't have this mine operating at the west end of Big Trout Lake. We're at the east end. We're on the downflow or the water flow of the lake. There's a concern about tailings, etc. And, people say, well, Mr. O'Neill, and we're going to get to this next, if we give the First Nations people this right of free, prior, and informed consent, nothing will be built in Canada, nothing will get done. And that's not true, my friends. Lots is getting done, lots more will get done. But there are these occasions in this country where the original owners of this land, and in many cases, particular owners of particular sections of this country, do have this Aboriginal treaty right to weigh in because of their cultural, spiritual, and real ancestral connection to the lands around environmental and resource development processes. And those people that would say the sky is falling, we must go and tell the king, the sky isn't falling. Things have a way of working out. And that's what the treaty relationship is. Just before we go on to the next article, I mentioned to you folks the treaty and Aboriginal rights of the First Nations people are affirmed and guaranteed. There are Aboriginal rights because you see, most of this country was settled by treaty, but there's only 3 treaties in British Columbia. So British Columbia is really non-treaty country. It's sort of Aboriginal title country. There's no treaty there yet. Large swaths of Algonquin Provincial Park on the Ontario side and on the other side of the Ottawa River in Quebec, there's no treaty in these areas. And the Algonquin people and the Crown have been working on a treaty there since 1975. There's no treaty. Our firm is working on a case up by Pic River, west of Sault Ste. Marie and east of Thunder Bay. There's no Pic River people did not sign the 1850 Robinson Superior Treaty. So there are swaths of this country that are under original ownership, Aboriginal title, we call it. All right, so we go on to the next article. How much time left, please, Carolyn?
We still have about 28 minutes.
Okay, so here's an article I wrote. I wrote this in June of this year, and I'll just put, there it is. And the reason I wrote it was because the Kamloops, unmarked graves had been found at Kamloops about 2 weeks earlier, and our country was in shock. We knew that there were more people loved ones to be found in the ground. We knew there were the elders that talked about other areas of the schools and churches where they believed there were graveyards. And this country, this was a little bit of a learning and turning point for this country. My feeling was with the discovery of the 215 graves at Kamloops, and since another 750 found in other places, I think it's 1,000 in the last couple months, that there's a bit of a turning point in the national consciousness. And it brought me back to Prime Minister Harper's apology for residential schools. And then it brought me back to a real hard truth we're going to get to. And this is a lot for people to sort of take in, but I'm honored to be able to try to explain this as I see it. So I said, do the attitudes that inspired residential schools still prevail in Canada? People must have thought the guy's out of his mind. Like, we're beyond that. We've apologized, as Carol and I talked earlier. We've dismantled the schools. We're moving on. We need to get past this. Well, I wrote an article with a question mark, and let's read part of it. June 4th, 2021. This is the date of my article. And I quoted, two primary objectives of the residential school system were to remove and isolate children from the influences of their homes, families, traditions, and cultures, and to assimilate them into the dominant culture. These objectives were based on the assumption Aboriginal cultures and spiritual beliefs were inferior and unequal. Indeed, some thought, as was infamously said, to kill the Indian and the child. Today, we recognize that this policy of assimilation was wrong, has caused great harm, and has no place in our country. There is no place in Canada for the attitudes that inspired the Indian residential school system to ever prevail again. June 11, 2008, Prime Minister Stephen Harper, House of Commons apology. This apology came after the Indian residential school settlement, and this followed. Well, then I went on to write. I thought about these words when, like countless other Canadians, I first learned of the recent discovery of the remains of 215 children buried on the site of what used to be Canada's largest residential school. That these children lie here is a direct result of long-held Canadian attitudes and policies that Indigenous cultures and spiritual beliefs are inferior to those of the dominant culture. But there are two sides to the Canadian apology coin. Stated simply, as long as concepts used to justify European sovereignty over Indigenous lands and peoples remain in law and are not repudiated, then the hard fact remains that the attitudes that built and inspired the Indian residential school system continue to prevail in Canada. What do I mean by this? Put simply, while Canada's Indigenous peoples were never conquered, and we go back to Justice McLaughlin, 2004, Haida Nation, while they were never conquered, claims of sovereignty over and title to lands in Canada are largely based on legal doctrines similar to the assumptions upon which the residential school system itself was based. The report of the Royal Commission on Aboriginal Peoples, 1996, put it this way. Europeans arriving in North America attempted to justify their assumption of political sovereignty over Aboriginal nations and title to their lands on the basis of a reinterpretation of prevailing norms in international law at the time, in particular, the doctrine of discovery. Upon the discovery, that's into quotation marks, upon the discovery of the North American continent by Europeans, according to this doctrine, the newcomers were immediately vested with full sovereign ownership of the discovered lands and everything on them. When faced with the fact that the lands were inhabited by Aboriginal peoples, European commentators such as the preacher Gray popularized the notion that Aboriginal peoples were merely in possession of such lands, since they could not possibly have the civilized and Christian attributes that would enable them to assert sovereign ownership to them. Over time, these ethnocentric notions gained currency and were given legitimacy by certain court decisions. So in 1996, the Royal Commission authors made several recommendations, including the following. Terra nullius and the doctrine of discovery. Terra nullius is the idea that when the newcomers came here, no one was here, terra nullius. But there was also the second concept called doctrine of discovery. And so the recommendations were, turn the page, Carolyn, we get to the first one. Federal, provincial, and territorial governments further the process of renewal by acknowledging that concepts such as terra nullius and the doctrine of discovery are factually, legally, and morally wrong. And then I went on to say, fast forward from 1996 to 2015, when the final report of the Truth and Reconciliation Commission was filed. In the intervening 19 years, Canada had not taken the required and necessary steps to repudiate the racist attitudes that both inspired the residential school system and the doctrine of discovery. Accordingly, the Truth and Reconciliation Commission made 3 of its 94 calls to actions as follows. Number 43, and there are 94. Number 43, we call upon federal, provincial, territorial, and municipal governments to fully adopt and implement the United Nations declarations on the rights of Indigenous peoples as the framework for reconciliation. 44, we call upon the Government of Canada to develop a national action plan, strategies, and other concrete measures to achieve the goals of the United Nations Declaration on the Rights of Indigenous Peoples. 45, we call upon the Government of Canada on behalf of all Canadians to jointly develop with Aboriginal peoples a royal proclamation of reconciliation to be issued by the Crown. The proclamation would build on the Royal Proclamation of 1763 and the Treaty of Niagara of 1764 and reaffirm the nation-to-nation relationship between Aboriginal peoples and the Crown. The proclamation would include, but not be limited to, the following commitments. 1, repudiate concepts used to justify European sovereignty over Indigenous lands and peoples, such as the doctrine of discovery and terra nullius. 2, adopt and implement the United Nations Declaration on the Rights of Indigenous Peoples as the framework for reconciliation. 3, renew or establish treaty relationships based on principles of mutual recognition, mutual respect, and shared responsibility for maintaining those relationships into the future. And 4, reconcile Aboriginal and Crown constitutional and legal orders to ensure that Aboriginal peoples are full partners in Confederation, including the recognition and integration of Indigenous laws and legal traditions in negotiation and implementation processes involving treaties, land claims, and other constructive agreements. So that was the recommendation in 2015. Of course, one of the recommendations was a National Day of Truth and Reconciliation, which is today, the first national holiday, which now takes us to maybe some good news. Maybe some good news, because, you know, history can be, you can learn some hard lessons in history and some, but moving forward, we'll move to the last document I want to share with you today. And, oh, just before, well, I'll bring it up. This is the United Nations Declaration. Have you got that now? On the Rights of Indigenous Peoples Act. This received royal assent either June 15th or June 18th. I forget the date. This year. This was one of the last acts of the Liberal government before the election was called. And because we didn't have a Governor General, because Mary Simon had not yet been appointed and Julie Payette was not occupying the office, this act to be given royal assent, we learned a long time ago in law school. I don't want to tell you folks how long ago it was for me, but to give any federal legislation royal assent, the Governor General has to sign off. And if not the Governor General, the Chief Justice of Canada. So Chief Justice Wagner of the Supreme Court of Canada gave this act royal assent. Just before we turn to this is hard for me to say in a certain way. I have to say it with respect. None of us can remake history, but we can learn from the mistakes of the past, and we can work towards rebuilding trust, mutually respectful relationships, and reconciliation. But if you could narrow down this doctrine of discovery, you'd trace it back to Christopher Columbus coming here in 1492. And shortly after he returned, he flew under the flag of Aragon and Castile. No planes then. He was flying fast, but he was in a ship. When he returned, the Pope of the Catholic Church had to deal with the discovery of these immense lands on the other side of the world. And something called a papal bull was issued, P-A-P-A-L, bull, B-U-L-L. And the one I'm speaking about is called Inter Caetera. That's Latin, I-N-T-E-R, Caetera. I think it's C-A-E-T-E-R-A. You might want to look that up, but it kind of says to the Portuguese and the Spanish people at the time coming here that, you know what, those people aren't Christians over there. And, you know, they're not tilling the lands. They're living a different, they're not under agricultural tillage of lands. They certainly don't have our European attributes of attending to the land, tilling the soil. So, and they don't have our culture. So they're not Christians and they don't have our culture, and the lands are different. So you know what? They can only possess those lands and not own them. So get your flag in there quick. And, you know, finders keepers. Imagine me having to say this today, that lies at the heart of the dispossession of lands and resources of the indigenous peoples of this country. You know, I didn't wake up one day and say, I'm going to try to figure this all out. I was like, I was that pinball wizard kid, you know, like you guys are too young to remember the Who probably, but you know, when you play pinball, that little ball goes out. In my day, you didn't put much in the pinball machine, and it's bouncing off everything. I had no idea what my learning path was going to be, but I can't turn back the tide of history. But I can say that we have to understand, and this I think is a truthism, we have to respect the culture and the spirituality and the deep connection of Aboriginal peoples to the lands of this country. The Creator put them here. They have inherent rights. They're at peace and friendship with us, but they want to be respected. And I've been in some hot spots. I flew out to Wet'suwet'en pipeline territory a year and a half ago. I was put out of some meetings at Oka in 1990. I wasn't in Oka, I was in other places, and that meeting ended pretty quickly. I know where I was in 1995 when the Premier of Ontario uttered certain words, and the Ipperwash Inquiry was called. The days of people, we need to treat the Aboriginal peoples with respect to their culture, their connection to their lands, and their spirituality with the respect they're entitled to. How much time left, Carolyn, before we conclude? Just give me an estimate.
15 minutes.
Okay, so on my second last paddling trip in 2018, I reached Great Slave Lake in 2019, but in 2018, my partner and I paddled Fort McMurray to the Paw. We went backwards, even though we're following the route of the Voyageur, because we had to go up the Clearwater River from Fort McMurray, and we had to cross the largest portage in the Canadian fur trade, 19 kilometers. It took us 2.5 days to climb these hills from what we call the Clearwater River system that flows into the Athabasca River. And we had to come up and over the Haida land down into the Churchill River system. And we got to the other side, went through La Loche, very hard-pressed community. And we ended up getting to Pelican Narrows in Saskatchewan. And we camped out at a moose camp, and the name Linklater was there. And Linklater is an interesting name because there's Linklaters in Athabasca where I've worked. There's Linklaters up in Treaty 9 area, northwestern Ontario. And Linklaters would have traveled the waterways. They would have worked their way up the Churchill and different rivers. So if there's Linklaters sort of in Treaty 9, northwestern Ontario, it doesn't mean there can't be Linklater connection in northern Saskatchewan along a river system. So we camped overnight, got up the next day, and we were coming around a corner of Pelican Narrows. And we're just about through the community. Kids were coming down, waving at us. And we were at some fast water, and we didn't really, I couldn't grab the shore or a tree, and I really couldn't. And this man came down, and it was Mr. Linklater. And he said, "Where did you stay last night?" And we thanked him. And he said, "Well, those are my hunt grounds with my family and my relatives. I hope you had a good night." And yeah, we left everything in order. And he said to me, and you have to appreciate, my canoe is almost battering off the shore, but I was able to keep it from touching. and the winds were picking up. He said, I just want people to understand one thing, just to respect us for who we are. And I think that's the central teaching of today's webinar. You know, he didn't have to come to the shore. He didn't have to be the last person there. And he didn't have to say those words. And I've written those words in another article called The Mikisew and Paddling Teachings. That's my 2018 article. And I often think of that short discussion with him. It lasted less than 3 minutes, probably 2.5 minutes. So I just wanted to share that with you. So we'll now move to the United Nations Declaration on the Rights of Indigenous Peoples. In the dying days of the Liberal government, our country accepted the United Nations Declaration of the Rights of Indigenous Peoples and said that as follows. You want to turn up paragraph 4 of that act. Purposes of act. That's good. The purposes of this act are to affirm the Declaration as a universal international human rights instrument with application in Canadian law and provide a framework for the Government of Canada's implementation of the Declaration. Paragraph 5. The Government of Canada must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure that the laws of Canada are consistent with the Declaration, being the United Nations Declaration on the Rights of Indigenous Peoples. And then they talk about content and measures. And if you could turn to Carolyn to paragraph 6, sub 4, time limit. Just before, yep, there you are. I think you're there. Yep, time limit. The preparation of the action plan must be completed as soon as possible, but no later than 2 years after the day on which this section comes into force. So this is Canada accepting the United Nations Declaration on the Rights of Indigenous Peoples. Now we'll go back to the preamble. It's very, very lengthy. There's over 20 preamble clauses, but I'll bring up a few of them. Let's turn to preamble clause, Carolyn, number, I'll just count it here. 1, 2, 3, 4, 5, 6. Why don't we go start with number 7, whereas Indigenous peoples have suffered historic injustices. You okay with that? Whereas Indigenous peoples have suffered historic injustices as a result of, among other things, colonization and dispossession of their lands, territories, and resources. Whereas the implementation of the Declaration must include concrete measures to address injustices, combat prejudice, and eliminate all forms of violence, racism, and discrimination, including systemic racism and discrimination against Indigenous peoples and Indigenous elders, youth, children, women, men, persons with disabilities, and gender diverse persons and two-spirit persons. Whereas all doctrines, policies, and practices based on or advocating the superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences, including the doctrines, remember the doctrines of discovery and terra nullius, are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. So there we have that language about the doctrine of discovery, how it's a racist document, how it's unjust. Now, a lot of negotiations went into this act. Some of the First Nations didn't feel it was strong enough. Canada's 2-year promise to align Canadian laws with the Declaration. There was quite a battle, folks, on this one. The nice thing about being a retired judge and being a lawyer is I can get into it a little bit. Now, the NDP and the Liberals passed this. The Conservatives Senate were outvoted on this. The senators, they're worried about something called free, prior, and informed consent, that First Nations will have a veto over resource extraction and rights in this country. And as the government has said, it's about a process. It's about a process leading to dialogue, constructive agreements, ultimately consent. It's about a process. But in any event, there was political division about this act. back in 1984, no, a little bit later than that, I'm sorry, maybe about back in 1990, when I was a lawyer at with Katie O'Hara and her dad at Miller Mackey in Sudbury. And hi, Katie, I hope you're listening. I wrote an article in the Sudbury Star, and basically I said that Aboriginal law is a mixture of history, politics, and the law. So everything we're talking about today, you can feel the history here, and you can feel the legal. We've talked about several Supreme Court of Canada decisions. You can feel that, but you also have to be aware. We have to be aware that we're engaged in a political arena on some of these issues as well. But again, my time traveling the territories and working with the people, and you learn something new every day. To me, it is about the respect. I'm working on a few projects, for example, in Northern Ontario right now. And, we need to put a 4-lane highway in between Toronto and Sudbury. Well, we're going to have a highway. And we were close to having an agreement about a portion of that highway before the last election, before the last provincial election. But we need to get to these decisions in a respectful and reasonable manner. And First Nation people should not be poor in their own lands. First Nation people should not grow poor in their own lands. They're entitled to a share of the wealth here. They're entitled to a share of value. That's protected in the treaties. Much of that is at issue in the Court of Appeal decision in Restoule, and we'll await to hear from the Court of Appeal about that. But the elders that you work with and talk to will tell you, we never agreed to grow poor in our own lands. And I guess I might conclude with this. It was amazing to me over the years to come to realize that, in fact, the spirituality of the First Nations people, I work particularly with the Anishinaabe people of northeastern Ontario here. Their spirituality is actually rooted into the land. That's their connection. It's not so much a parish or a church or a building they'll go into, but it's their connection to the lands, the waters, the trees, the medicine. So that concludes what I have to say today, my friends. Thanks for listening. You can send questions later if you want. And it's honestly been a real honor and a privilege. It sometimes feels like a bit of a heavy honor, Carolyn, because it's kind of a heavy subject, but I just want to say miigwech. Thank you to all for your time. And I guess we're going to turn it over to questions. What time of the day is it, Carolyn? Right now.
We've got about 3 minutes. So I think that I don't see any open chats right now or questions. So I think I'd just like to end on the note of asking you personally whether you feel hopeful about Canada changing and Canadians changing these ethnocentric attitudes that frankly a lot of folks still hold. How do you feel about Canada positioned to tackle that?
Well, I think that's a great question, and I'm a lot more hopeful now than I was 5 or 10 years ago. So much has changed. The Supreme Court of Canada has helped move the barometer with its legal principles. The Supreme Court has been a great help. The Truth and Reconciliation Report of 2015 is major. And I think in the last 5 years, even today in the Globe and Mail article, Canadian people are much more attuned to these issues. So I am hopeful, but remember, the pendulum of injustice swung for 150 or more years, and it's just not going to swing back in 1 year. I am hopeful. I think I'm hopeful that in my grandchildren's lifetime, we will get to a place where we can say reconciliation is much more attainable and achievable, and has occurred in different places across the country. So I am hopeful. It's going to take a few more generations. Thank you.
Well, I appreciate that, and we very much appreciate your time, and I'm happy that we're able to end with that note of hopefulness on such an important day. And I'd like to thank all of our participants for attending, and certainly for your time as well. So we are mindful that people have to get on with their day. So thank you so much for attending, and hopefully this will only be the first of many more Reconciliation Day events that we're able to hold. Thank you, Stephen.
Thanks so much to your law firm. I really, really appreciate it. Thank you.
Okay, bye now.